Okay, it is Tuesday, December the 11th, and welcome to week 6, the final lecture for Introduction to Criminal Law. I told you 6 weeks would go very fast. This is it. Uh, all assignments will need to be in by this Friday, December 14th. No exceptions. 11:59 p.m. Central Standard Time. Any papers who come in after that will not be graded, and zeros will be given for those papers. The only assignments that if you missed right now, that you could turn in are week 4 and week 5, as we're in week 6. You cannot do 1 through 3. If those have not been, arrangements haven't been made prior to, you cannot turn those in. I will not be grading those. I will be giving zeros for weeks 1, 2, and 3 if you have not already completed those assignments. Weeks 4 and 5 and 6 are what is on the table right now. So let's get started, and let's look at and let's see. Let me share my screen with you. Okay, this is a familiar page, the course home page. Then it tells you your lectures there. So now let's see what's in our week 6 announcement, Defenses to Criminal Liability. You should have read or are reading chapter 10 of the textbook. And we'll take a look at briefly, mental disorders or sanity defense, involuntary intoxication, mistake of fact and mistake of law, self-defense. You're going to use key terms to help you prepare for the exam, and mistake of law and the practice quiz. You have your discussion posts that are due tonight. For your initial post, 11:59 p.m. Central Standard Time, murder or self-defense. And then your reply post due this Friday. Notice, not Saturday, 11:59 p.m. Central Standard Time. And then your quiz, which is timed, which covers the materials from 4, 5, and 6 chapters for your exam. And then the quarter ends December 14th. Very, very, very important. And then if you could take time to complete the end of quarter evaluation that you received in your email, we appreciate that as well. Okay, so I hope you're finishing strong. Let's take a look at the course calendar for the final time. And it shows you where we are right here. Week 6 on the 10th, which was yesterday. Today's date, your initial post, and then your live lecture, and then your reply posts, and your written assignment, which, as you should know already, is the quiz. So you want to make sure that you get that done. That's a time quiz as well. So now let's take a look at the module for week 6. And in the module for week 6, it's coming up. Look again at the assignments, which, as you can tell, are just the discussions, initial post, reply posts, and then your quiz. And 30 minutes. This again relates to the second part of the course, crimes against government and public order, crimes against moral values, and then today, defenses to criminal liability. The best way to prepare is for you to do those practice quizzes that I had been telling you all along this quarter. Also, make sure that you work those also exercises that we give you as well. And then, of course, make sure you have read the chapter. Okay? So now let's go into the lesson content tab. So we're going to talk about things like self-defense and other issues. Again, we're going to talk about mental disorder, involuntary intoxication, mistake of fact, and mistake of law, and conclude with self-defense. You're going to make sure that you do those practice terms and all of these practice things that are necessary to help you to do well on that quiz, which is equal to your final. So let's start off by talking about the mental disorder or insanity defense. You should be aware of the fact that the insanity defense is what we call one of the affirmative defenses. Another popular affirmative defense is self-defense. Basically, what it is that you don't deny that you committed the offense. You admit you committed the offense, but with the insanity defense, what you're saying is you're excused from the actions because of the mental state. And so we're going to talk about the different tests. Be aware of the fact that the insanity defense is a very difficult, very complicated concept, so I won't get into it too deep. But what I will say to you is that it is rarely successful, and there are different rules for that. So with insanity, individual should be aware of the fact that if a person is found not guilty by reason of insanity, they're not released. They end up going to a mental hospital, and they stay there until they are rehabilitated. If they are committed to the hospital, and they could be released back into society if a doctor is of the opinion that the person is competent and safe to be released. That has happened a few times with individuals. I think it's John Hinckley, the shooter of, I think it was President Reagan. He didn't shoot Reagan actually, but he shot Brady, one of his assistants, and anyway, and also one of the Secret Service agents, McCarthy, who was the chief of police out in Orland Park, Illinois. But he, I think, is at the point where they're ready to release him. But almost every person who is found guilty of insanity very rarely hits the streets again. So almost every state in the United States, with the exception of 4, Idaho, Kansas, Montana, and Utah, there is an insanity defense. Now, those states do allow for guilty but mentally ill verdicts, but in those states, if a person is determined to be not guilty, the Senate is then committed to, of course, treatment once again. So there are 3 types of general defenses that are insanity defenses: the Norton Rule, the Durham Rule, and the substantial capacity test. And we're going to just scratch the surface on these. Now, with the Norton Rule, which came originally from England, a person is found not guilty by reason of insanity if at the time they committed the offense. The key thing is at the time they committed the offense, the mind was so diseased that it prevented the individual from knowing right from wrong. And it's also called the right-wrong test. For example, it says here that a person who's a defendant, remember, you're raising that defense, and you have that burden to prove it by preponderance of the evidence. That at the time of an act, for example, murder, the defendant thought that they were stabbing someone. When they stabbed someone with a knife, they thought the knife was a straw, or either they didn't realize it was a weapon, or at the time the defendant knew they were stabbing someone with a knife, but for any reason thought that it was absolutely nothing wrong with killing the victim. In other words, they didn't know right from wrong at that particular moment. Florida presents an example is that the defendant had a mental infirmity, disease, or effect, and the condition put them in a state where they didn't know what they were doing or the consequences of, although the defendant knew that they were doing something as consequences, and defendant didn't know what they were doing was wrong. So you reach the stage there where pretty much in a situation like that, it has to be that you are out of touch with reality. And I don't mean high on drugs either. I'm talking about that your state of mind was so damaged at the time of the offense that your mental capacity to make judgments or decisions was very, very, very seriously impaired at the time of the offense. Again, you don't go out, you end up in the hospital. The Durham rule is used very rarely, and it says here in New Hampshire, the product of mental illness tests. According to this rule, it says it's the product of a mental disease that excludes criminal liability. Came out of a 1954 Supreme Court case, Durham versus U.S., and said that the Norton rule had problems. In other words, mental illness was more complex than simply right or wrong. Well, the definition in the Norton test of right and wrong is not like what you might think as a regular person, but that it is actually the wrong or right and wrong is blinding right or wrong. So the Durham rule really is kind of like an attempt to reject it, but it's not quite. So the Durham test is easier or more liberal than the Norton. It stretches the purely intellectual question is, did the defendant at the time know the difference between right and wrong? And that is expressed in Norton. So it's more easier to prove the Durham test. But once again, it's, how should I say, short straws, long straws type of argument. The point of the matter is it still operates on the basis of the mental illness of an individual being involved. The final one is a substantial capacity test, which came across through what we call the Model Penal Code and tried to take Norton away, that a defendant didn't know the difference between right and wrong, but instead that because of mental disease, they lacked substantial capacity to appreciate the wrongfulness of their conduct or to conform to requirements of law. Now, the substantial capacity test, as stated here in the Wisconsin statute, a person is not responsible for criminal conduct if at the time of the conduct, as a result of mental disease or a defect, the person lacks substantial capacity either to appreciate the wrongfulness or to conform to the conduct requirements of the law. Now, they all sound alike, I'm sure, to you. The key thing is that they are close akin. And remember, the formula, though, is the state of mind of the individual at the time of the offense. And, if the person who is already presumed to be sane, it is determined that their actions and all the surrounding circumstances is such that that person was not in touch with reality by a preponderance of the evidence or clear and convincing evidence. These are both civil standards. Then that individual could be considered as insane. And finally, the last paragraph, it says, when a defendant wishes to pursue a not guilty by reason of insanity prior to trial, a hearing is held to determine the mental state of the individual. And then psychologists, psychiatrists testify their various opinions, and the court determines whether the person is insane. In some cases, a jury could render a verdict decision that the person is not sane or incompetent or not competent. And so, anyway, most of these people do spend the rest of their lives in hospitals. We always look at here in Illinois what I consider the Amanda Wallace test as the basis for determining insanity. Amanda Wallace was a woman who the Department of Children and Family Services took the child from her, and then for some reasons they decided to return the child to her. Well, shortly after she got the child back, she hung the child, and she was then arrested. The child was dead, and then I saw her actually in jail, and she was sitting in a corner, and she was balled up, and she was rocking. She wasn't, you could tell that there was something wrong with this individual. Well, this was the state of mind that at the time when she was hanging this child, she didn't appreciate or recognize that that's what she was doing. So that's why we call it the Amanda Wallace test. And it falls under substantial capacity. But the point of the matter is that at the time she did this, she couldn't conform to right from wrong or the law because of her diseased mind. And she'd spend the rest of her life in a mental institution or a hospital. And that's kind of the way it is. I can tell you that in all my years of people that I represented, I've had probably 3 cases where I had individuals that I attempted to try to use the insanity defense. The first step that we had to do was we had to submit the individual to a psychological test. And because most of our clients could not afford private psychiatrists, then there was a Dr. Reifman, who was the county psychiatrist, and he would examine people, and hardly ever did he find an individual insane. Therefore, insanity defense wasn't used. I never had a chance to use it, and like I said again, I don't know too many who use it. I do remember the Amanda Wallace case, and then there may be a few more, but the most famous one that jumps out at us and jumps out at me because I saw Amanda Wallace is the Amanda Wallace case. So that's a possible affirmative defense. Involuntary intoxication is the next topic. It's also an affirmative defense. Again, you say, yes, I did the offense, but I was intoxicated involuntarily. Now, involuntarily is not a person who is an alcoholic who drinks too much. No. A person can't themselves drink and become intoxicated and then claim intoxication. That is not going to fly. But here are some examples that you kind of get the idea. And again, you get the preponderance of the evidence because the burden is raised by the defense to as a ability to say that the person was not able to make a decision, they were impaired by alcohol or drugs. Say it is an affirmative defense to a specific intent crime. Has to require intent, mens rea, for which the defendant has the burden to prove by, as I said earlier, and continuously, the preponderance of evidence that they voluntarily or legally obtained and properly used medication or other substance and did not know or reasonably should not have known that they would become intoxicated or impaired. Now, with the medication thing, there is oftentimes an argument that the medication itself generally has a disclaimer on the medication that tells you of possible effects. And so that is actually something that often negates the should have known, because that means that you could read and you see what the statement says. In Kansas, intoxication states that a person charged with a crime in an intoxicated condition at the time the crime was committed is a defense only if such condition was involuntarily produced and rendered that person substantially incapable of understanding right from wrongfulness. Now, the intoxication defense involuntarily can happen in a situation where someone slips you a Mickey or puts something in your drink. You thought you were drinking water, but it had something in it that sent you on a trip that wasn't tasteful, excuse me, and you couldn't taste it. So, but it must be clear that it was not done for your own possible escape or enjoyment. So it says the intoxication defense can be applied in those cases where a criminal law that was violated had the elements of intent and state of mind. For example, didn't know the difference, as the same as with the mental, between right and wrong. And involuntary intoxication may happen if a person, as I said before, the drink is spiked, or maybe sometimes a person may have inadvertently taken 2 doses of the medication, those kind of things. Now, here's an example here. It says a college student, Jim, has been partying all night, but has a test the next day and doesn't want to fall asleep. So one of his classmates offered him a white pill, says it's caffeine, and it'll help him stay alert. But the classmate didn't tell the truth, and the pill actually was a methamphetamine hydrochloride pill, and had the adverse effects, made him drowsy, causing the person to go into a panic and rage. So while that person was in that intoxicated stage, he breaks windows of stores, destroys merchandise, and arrests him. Jim would have the burden of proving that he was involuntarily intoxicated, and in that case, he wouldn't be found guilty of vandalism. So the key thing is someone slipped something in on him. And that's the way involuntary intoxication works. Now let's talk about mistake of fact and mistake of law. First, let's talk about mistake of fact. When somebody commits a crime, but they misunderstood the fact or an element of the crime. Now, let me say very clearly up front that ignorance of the law is no excuse. But look at how the statutes generally read. As in the state of Missouri, it says a person is not relieved of criminal liability when they engage under a mistaken belief or fact, unless the mistake negates the existence of the mental state. So the mistake has to negate the mental state. So under Missouri law and other statutes, the defense can be claimed if the person mistaken action is related to an element of the law in question. An example, let's look at the following. Lisa is making a large purchase at a home goods store, including a push mower. There's a large box when she puts on the bottom of the cart. The top of her cart is filled with several other items. While paying for all the items, she's distracted by, on the phone talking and doesn't pay attention and that the clerk scans. She pays the large bill with a debit card and leaves the store. She's then stopped by a loss prevention officer or a store detective who tells her she didn't pay for the lawnmower. The officer calls police and suggests that she be charged with theft. Lisa, in this case, would probably be not guilty under a claim of mistake of fact because she intended to pay, but she had no intent to steal. But there was neglect on the clerk to scan it. So this would be an example of where that defense is raised. In other words, it's an error. It's an error. Okay. Mistake of law is a defense can be claimed if the person violated the law believed their acts were legal. Now, it's not the same as ignorance of the law because here's how it applies. A person relied upon a law that was later found to be unconstitutional because they had no way of knowing that. A person acted in good faith, consistent with what the courts have said, but didn't apply it properly. Person acted on the advice was given by a person responsible with administering the law, such as a police officer, or a person committed an act contrary to law that has yet to be published. In other words, there is the law is there, but it's not made available for the people to know. So there was no knowledge of the law, no ability or capacity to know about the law. And then, so this is included in some states like North Carolina. It says that mistake of law, which states that a person's good faith or belief doesn't constitute a crime and is an affirmative defense if they act in a reasonable reliance upon a statement of law contained in a statute. Same kind of stuff as earlier: judicial decision, order, administrative order, official interpretation of a public servant. So, so you should be aware that it's not just the idea of ignorance, but rather the defense mistakes are made from the way the law is in itself. Okay. I'm not going to talk about Paul's situation here. So let's talk about self-defense as our final thing. Now, most of us lawyers, including my very first case that I had, which was a double murder case, the very serious case. I had been 2 years practicing, and I had a very serious offense where in self-defense, you do admit that you did. In this case, my client used a gun. I admitted that he used a gun, but that he was justified and that his actions were comparable to save his life or protect the lives of others. So self-defense laws don't presume that force is justified, but rather that the proof is that the person who used the force is used it to stop unlawful interference with someone else, such as serious injury or something of that nature. Someone raises their hand to punch, you take a gun out and shoot them, you can't say that was self-defense. But if a person has a weapon on you, a knife or a dangerous weapon, and you shoot them, then you can argue that, of course, depends on the proximity that they were. So let's look at a few of these. And Illinois has a real good one that I'm very familiar with. It says, Bob is walking on the sidewalk with his girlfriend, Margaret. Bob and Margaret are approached by a drunk man who threatened to punch Bob. Bob attempts to avoid the conflict and tells the man, just keep walking. The man shoves Bob and draws his fist back at him. Bob reacts quicker, punches the man in his face, and he falls onto the ground. Bob, upset because the man just tried to assault him, jumps on top of the individual, beats him until he becomes unconscious. Margaret pulls him off the man and they wait for the police to arrive. So the question is, was Bob's force to stop the intoxicated man legal and justified? Well, the question is, up until the point that he got on top of the man, he probably had a chance. But after that, he went too far. He went too far. Let's see what Illinois says regarding that scenario. Let's apply it to this. So a person is justified in the use of force against another when, to the extent they reasonably believe that the conduct is necessary to defend themselves or another against such imminent unlawful force. It says, but he is also justified in using the force which is intended to likely cause death or great bodily harm only if there's a reasonable belief that the force is necessary to prevent imminent death or great bodily harm to himself or another, or the commission of a forcible felony. So it is clear that Bob's initial force was justified, but the great bodily harm when he beat the man unconscious is important to note that, and so as a result, he probably negated his argument of self-defense. Some states, or most states in the U.S., don't require retreat. I remember when they used to require retreat, I used to think that was a very crazy rule, which meant that you should try to use a way of escape. But people would oftentimes get hurt in those scenarios. So now, with the stand your ground, which became famous in the Trayvon Martin case out of Florida, it doesn't require retreat, and that the person doesn't have to, and they can stand their position using force to stop the unlawful interference. And so, but you cannot assert that claim if you're committing a crime when you're attacked. Also, people can't claim self-defense in cases where they provoke the attack. So, and so self-defense has to be basically to protect yourself or another in a situation. That's what it boils down to. The battered women syndrome is a defense that's oftentimes used in cases where individuals have been the subject or victim of domestic violence. And as a result, they reach a stage where they've gone through this so much that they develop a condition called battered BWS, or battered women syndrome. And it's been used many times because a person will kill someone after they have been guilty of beating that person consistently, and it changed their mental state to the such that they were fearful that any time that it could happen. I do know of a case of a young lady who was abused by her husband in Illinois. She wasn't able to use the battered syndrome. When I read the transcript, represented her and got her off on it because she was the victim of a big man. She was a small lady many times. The only thing that she did wrong, according to the finding of the court or the jury, was that she waited for him to go to sleep, and then she shot him multiple times. So it has to be in an imminent situation where a person is in danger. So let's look at this example here. For example, Diane has been physically abused multiple times by her husband, Jim, over the past 10 years of marriage. Each time it occurs, he's drunk, and she's battered and been knocked and choked and unconscious. One night, Jim comes home drunk, and they start to argue. Jim begins to escalate, and Diane, fearful that she will be battered again, shoots him. So she's likely to argue BWS. And she probably could win in a situation like that because she was imminently in danger of another beating. And so I'm not going to go to this video, but you can take a look at this video on your own time and see it. But you see how it works. The castle doctrine, another type of self-defense, is claimed by individuals when they're protecting the castle, which is their home, and permits persons who are occupied to use deadly force to stop intrusion. Now, the castle doctrines don't require the person within the within the dwelling to retreat or prove that the person unlawfully entered, but that doctrine is used when they feel that they're in danger and the person has come into the home. Instead, it says people within the dwelling, when the unlawful entry is made, can use deadly force, because they don't have to determine what the intent of that individual is. They violated their private space, their home. The castle is supposed to be a place where you can relax. That's your home. And various states have castle doctrine laws. For example, here's a Kentucky law. It says a person is presumed to have held a reasonable fear of imminent peril, death, or great bodily harm when using defensive force intended or likely to cause death if, now, pay attention to these two ifs, the person against whom the force was used was in the process of unlawfully entering or forcing into the resident or attempting to remove someone against their will from a dwelling or resident occupied vehicle, and the person who uses the force had reason to believe that an unlawful entry was occurring. So the Kentucky statute, the reasonable fear of imminent death or serious bodily harm is presumed. And so the force is justified to stop the intrusion. And that's pretty much how. Now, it says it doesn't apply when the person against whom force used was a lawful resident. See, the place person had a right to be there inside a protected area, such as the owner, rental, title holder. There is no injunction that prevents them from being present. Then, or the person is to be removed as a child or grandchild or someone within custody of the individual, or the person using deadly force is engaged in unlawful activity, or the person against whom the force is used is a law enforcement officer performing their duties. Well, that would make sense. Okay. So the final thing I want to talk about is police officers. Police officers are held to a high standard and should use force that is comparable to what private citizens use, but it's more rigid because why? They carry a gun. So it says a police officer is privileged to use reasonable force to effectuate the arrest of another. Sometimes it says the force used, like hitting a suspect with a baton to take him into custody, will cause bodily harm or even substantial harm. So just so the force is reasonable to make the arrest, so you don't go too far, the officer will not be charged with battery. In contrast, if there's excessive force, then it would be considered as battery. So, like, for example, oftentimes the determination of when to use the stun gun, or either when there are multiple police officers, or definitely if you see a police officer beating, and like the Rodney King type of beating, or kicking an individual, or forcing a person to the ground when they have appear to have surrendered, or either the restraints, like the one that happened in New York City, where the individual said they couldn't breathe. I think it was Freddie Gray. Dealing with that, then there could be a possibility of a civil suit and or a criminal case. There's a case in Chicago where a police officer, Jason Van Dyke, who shot a youth 16 times, tried to argue that he was in fear of his life, but the video demonstrated he could not have been in fear of his life at the time, and that the deadly force that he used, 16 shots, even shooting an individual while they were on the ground, but they were trying to get up, that's excessive. And that person was found guilty of murder by a jury. So the deadly force that police officers use, it says, is rare. Depends on where you're from. You can tell people in my community that that's true, and they'll say, no way. There's too many numbers. That's what that whole issue of Colin Kaepernick and taking a knee is all about, the excessive number of minority men and women who are where excessive force is used, such as there was some issues about the Sandra Bland case down in Florida, the case in Ferguson that happened, Ferguson, Missouri, and several others. But anyway, police officers are held to a standard. And with today's society, with the cameras all over the place, the dash cam, the body cam, cameras all over the place, and everybody and his mother now has one of these things right here with a camera on it. There's a video of almost everything that takes place. From a Second Amendment perspective, sometimes the mere presence of a firearm can prevent the use of deadly force, and we won't go into that. So it is important that police officers, when they use force, are within the procedures and the policies of the department that they work in. It says here, for example, if a police officer makes an unlawful contact with somebody, such as stopping the person on a sidewalk, detaining them for no legal reason, any force used in conjunction would be inappropriate because there was no reason to stop the person. Use of force among police can also negatively impact, of course, community relations, which is what is happening in our times now. That's why you guys are learning to be professional, educated, and recognize you're dealing with diverse people. And then you can learn more about that by looking at these clips. Okay, and then you can answer these questions. So that's all I have. And so, again, these key terms, again, just got a few minutes. I'll give you a few of them. Let's go to flashcards. Get Adobe to allow it. Then you can see a test to determine if a person was sane at the time he or she committed a crime. To be successful, defendants must demonstrate that their mental capacity prevented them from knowing the difference between right or wrong was committed. And you flip the card over, and it tells you that's the Norton rule. Test used in New Hampshire that is applied to determine if a person was sane. And the defendant must demonstrate their actions with a practice of mental illness. That's the Durham. Then you go to the next one. A legal defense that permits a person to use reasonable force to stop an unlawful interference in themselves is self-defense. And that's so you go through and you look at these, okay? And that helps you prepare for the exam as well. Going right down, as soon as this boots back up, we will go to the bottom. And then, you can do the practice mistake of law, mistake of fact. You can go through the same thing. And then, above all, whatever you do, the practice quiz. Take the practice quiz. I've encouraged you to do that every week because the practice quiz helps you to know. So you go through these and you are defending a case where the defendant is accused of killing his friend during a schizophrenic episode and believed he had to kill his friend because he was the devil. You don't believe that Derek knew the difference between right and wrong. The blank test would be most appropriate in this case. And I would probably argue to say you could use the Norton test. Let's see what it says. Yep, the Norton test would apply here. So you go and you see that. David is hanging out with a friend at a local bar. Somebody places an unknown liquid in his drink, which caused him to go crazy, strip off his clothes. David is arrested. Next day, he has no recollection. What affirmative defense would he use? Intoxication. Yeah, because he was at a bar, but somebody slipped something into his drink. What level of proof must be met in order to successfully prove an intoxication defense? Beyond a reasonable doubt, reasonable suspicion, probable cause. This is it right here. Okay. So you could go ahead and you can look at all of those. I'm not going to go over all of those. So those are things that will help you to prepare for this. Okay. So I want to say to you that I'm going to give you a key phrase that I'm going to use, and I'm going to use self-defense. That's it. Give me that, and you get your points. Make sure you give it to me by Friday, 11:59 p.m. Central Standard Time. I do want to take time to say to you, I hope you've enjoyed this class. I've enjoyed teaching it. I hope that you have learned some things that will help you along the way. I hope I see you in other classes, and I feel free to reach out to me. I teach this class. I teach other classes as well, but hopefully I'll run across many of you further down the road. I wish you the best in your endeavors in the criminal justice field, and wish you a Merry Christmas and a Happy New Year, and hope to see some of you, not in this class again, in 2019 in future classes. Good night.